Are you married to a U.S. citizen or a permanent resident who does not want to help you with your immigration case? In this video, I'm going to talk about VAWA, which is a possible option for somebody in this situation. My name is Ashley, and I'm an immigration attorney. I have offices in Carlsbad, California, and in Bend, Oregon. There's been a lot of talk lately about VAWA. What is VAWA? VAWA case is for an undocumented immigrant who is married to a U.S. citizen or a permanent resident with whom they have suffered battery or extreme cruelty. And in this video, I'm going to explain what both of those things are and how somebody who is married to a citizen or a resident who is refusing to start their case with immigration, how they might qualify under VAWA. Before I get into that, I want to talk about quickly, what do you get with VAWA? If you qualify for VAWA, that means that you're filing your immigration case without the help of your spouse who is refusing to help you, without their knowledge, and that if successful, you will receive your green card, which will allow you to remain in the United States as a permanent resident. And you do that entire process from within the United States, meaning that you do not have to depart the country. VAWA requires that the undocumented immigrant have experienced battery or extreme cruelty by their spouse. There's other requirements as well, but this is the main one that I want to focus on in this video. Battery means physical violence. Okay, so the law says battery or extreme cruelty. Of course, if you have suffered physical abuse by your spouse who's a citizen or a resident, you definitely should call me to find out about VAWA and if you can start your case. Something important to note about physical abuse in VAWA is that it's not a requirement to actually have a police report about that abuse. The reason why is because immigration recognizes that a lot of victims who suffer physical abuse are not going to call the police and report it because they fear being found out and they fear being deported. So it's not a requirement to have a report. Of course, if you have a report, that's helpful and that's great, but don't be discouraged if you do not have a report and you have suffered physical abuse. There's other ways to talk about that in your VAWA case. What I want to focus on mainly in this video is the extreme cruelty requirement. Extreme cruelty means a lot of different things. It can mean emotional abuse, it can mean financial abuse, it can mean psychological abuse, it can mean verbal abuse. Many VAWA cases are successful without any physical abuse. And the reason for this is because immigration also recognizes that undocumented people who are in abusive relationships with their U.S. citizen or resident spouses are experiencing other forms of mistreatment, other forms of abuse, such as being insulted, such as being threatened with immigration things by their spouse when they get angry or they don't do what they want. Psychological abuse, being made to feel guilty for things that are not their fault. There's even financial abuse. That's when the spouse maintains complete control over all of the money in the house, or when the spouse requires that the undocumented person report to them all of the things that they spend money on. They want to see receipts. They get upset when the spouse purchases a small item that is a necessity that they don't like, where the spouse then feels like they have no power, they have no control when it comes to how money is spent in their household. They are completely dependent on their U.S. citizen or resident spouse for money. There's all different kinds of situations that might qualify for VAWA. One of the things that immigration is looking at when it comes to determining extreme cruelty is, has there been a pattern of this behavior? Has it not just happened one time, but is it happening over and over? Or is it happening, fairly frequently throughout the relationship? They're also going to view things that by themselves may not seem that bad. They're going to view a lot of isolated incidents in total. That's to say, they're going to look at the big picture to determine whether something counts as extreme cruelty. So For example, if you have a situation where your spouse, every so often during an argument makes fun of where you came from, or they tell you that you're not as smart as them because you don't speak English, or you don't speak English as well as they do. But maybe they say it in a joking manner. So they come across like they don't mean to be serious, but it actually really hurts you deep down inside. Well, if this is happening pretty frequently, not necessarily in every argument, but if it's something that's happening more than once, that is definitely something that immigration is going to look at along with other things that have been happening in your relationship to decide if there has been extreme cruelty. So that's why it's very important to know that if you are married to somebody who is refusing to help you with your immigration case, that you might qualify for VAWA, because usually when a spouse is refusing to help, there's other things that are happening beneath the surface, whether that's physical violence or whether that's other types of mistreatment that are not physical violence. So again, if you have experienced any kind of issues with your spouse, please give me a call to find out if you might qualify to do a VAWA case, which again does not require their assistance and it does not require their knowledge. Another important thing to keep in mind is that a VAWA case does not hurt your spouse in any way. That's to say that immigration is not going to contact your spouse. They're not going to come after them based on anything that you tell immigration, because the case is completely confidential by law. Immigration is prohibited from contacting your spouse about anything having to do with your VAWA case. I hope you find this video helpful. And once again, please don't hesitate to reach out if you are in this kind of a situation.